Thank you, Amanda. What a terrifically interesting panel. I was just riveted. So now we turn to our last panel. And what we hope to tackle is the tension between regulating online harm, online content, without falling into a surveillance state. And I'm really lucky to be surrounded, as they see them as they come up, with truly experts in the field. First of all, I will mention Owen as an architect of Canada's regulatory framework on regulating online content as Associate Assistant Deputy Minister for Cultural Affairs at the Department of Canadian Heritage. Welcome, Owen. Lorna Wood, that I would describe as an architect of the British regulatory framework to address the issue of harmful online content, Professor of Internet Law at the University of Essex. Errol Mendez, Vice President of the International Commission of Jurists and Professor of Law at the University of Ottawa, and the Vice President of the International Commission of Jurists, Manette Maillet, who is also Executive Director of the Correctional Investigations Office, but who will speak to us from her experience of having lived that intersection between addressing what has been referred to this morning by Christopher Parsons as harmful but lawful. So how do you actually resolve that tension within the rule of law? So I'm going to ask Manette to first set the stage on the basis of how you have been confronted, if I can use that word, that tension between protecting human rights and yet addressing harmful content.
Thank you very much, Chantal. Can you hear me okay?
Yes.
Okay. Yes, so I'm going to speak from the point of view of my experience as a former litigator with the Canadian Human Rights Commission dealing with cases of hate on the internet. So it's really a view from the trenches. I'll speak very briefly about the right of freedom of expression and the tension that arises between that right and the right to be free from discrimination, and of course the ensuing harm and sometimes violence that causes. I will also talk about what I observed regarding what hate on the internet looks like, just so that we can get, we can see it on the ground. What does this look like? It's not just something that we talk about philosophically or theoretically, it's real. And I'll end by sharing my experience with one of the hearings I participated in to flag the gaps that currently exist in the law. So I'm going to bring us back a bit so that the other panel members can bring us to a discussion about the future. So many of my litigation files when I was counsel for the commissioner were on alleged breaches of Section 13 of the Canadian Human Rights Act, the hate on the internet provision. Now, at that time, the mechanisms in place to deal with hate on the internet were the Canadian Human Rights Act as well as the Criminal Code. Now, as we know, the provisions in both of these laws were challenged before the Supreme Court of Canada as being inconsistent with the Charter's guarantee of freedom of expression. The court determined that while the laws did impinge on freedom of expression, the limitations were necessary and justified, and that people have a right to be protected from the harm caused by hate messages. Now, I'm going to talk about freedom of expression just for a moment, because we often look to the US and their absolute protection of freedom of expression. And one of the most cited rationales for free speech is found in a 1908 case at the Supreme Court of the United States in Abrams versus the United States. And it was in the dissent of Justice Holmes where he said, "The best test of truth is the power of the thought to get itself accepted in the competition of the market, and that truth is the only ground upon which their wishes can be safely carried out." So it's this marketplace of ideas that will generate what the truth really is. Now, this notion is based on the view that human beings are rational creatures who can distinguish truth from falsehood. And it, taking us way back, in 1966, a parliamentary committee on hate propaganda was formed. It was also known as the Cohen Committee, and they tabled a report. And in that report, they discussed this rationality of man. They took the view that individuals can be persuaded to believe almost anything as long as information or ideas are communicated in the proper circumstances and using the right technique. And I quote from their report, "We know that under strain and pressure in times of irritation and frustration, the individual is swayed and even swept away by hysterical emotional appeals. We act irresponsibly if we can ignore the way in which emotion can drive reason from the field." So that was 1966. I think it's safe to say that in 2022, we see so many examples in today's world where emotion and propaganda certainly drives reason from the field. And it has done at various times also in our history, sometimes often leading to tragedies. What I learned from my involvement in these hate cases is that hate propaganda has a goal, and that goal is to demonize the target community, to isolate them, and ultimately to convince the audience to participate in discrimination and attacks against them, or to stand by and do nothing when others carry out that violence. The natural and intended result of hate propaganda can be seen in many historical and recent tragedies around the world, whether it's in Nazi Germany, Rwanda, the former Yugoslavia, up to and including the Quebec City and Christchurch mosque attacks, or multiple synagogue shootings, and including the killing of a Muslim family in London, Ontario. The Cohen Committee concluded that Canadians who are members of any identifiable group in Canada are entitled to carry on their lives as Canadians without being victimized by the deliberate, vicious promotion of hatred against them, and that groups or individuals promoting hatred in Canada constitute a clear and present danger to the functioning of a democratic society. Also in the Westcott case that Mr. Dufresne talked about this morning, the Supreme Court upheld the constitutionality of human rights law controls on hate speech, noting that the risk of substantial harm from hate propaganda to the society as a whole was amplified by the advent of the internet and its potential global reach. So I'll share a story about one case that I had before the Human Rights Tribunal involving a neo-Nazi white supremacist, Mr. Alex Kobashian. At that time, we were dealing with hate propaganda mostly on websites. So it takes you back a bit. We didn't have the extent of social media that we now have. The remedy we were therefore seeking was for the author of the material on the website and the internet service provider, if we could find it, to cease and desist, which meant really to shut down the hate site. Now, we had a police officer who was part of a hate crime team here in Ontario, and he contacted us about wanting to be a witness in this hearing. He did this because he had followed Mr. Kobashian online as part of his anti-hate work, and he saw how Mr. Kobashian was drawing in other disenchanted youth, living in their parents' basement like he was, and he knew that he was violent against racial minorities. He had been charged with having beat up a Black man on a bus. He'd been charged with assault, but the hate crime charge was dropped because the prosecutor felt it would be too hard to prove. And as we know, criminal code hate provisions requires the consent of the Attorney General. So not an easy thing to do. The police officer came to us because he felt that if we could shut down his website, at least it would limit Mr. Kobashian's ability to recruit others and to organize them to take action. Section 13 then was the only legal mechanism to get this material off the internet, as the criminal code was not an option. So it was certainly harmful, but not quite criminal. And as awkward as it is to have a Human Rights Commission deal with this type of material, for several reasons, complainants are afraid to come forward, getting cooperation of internet service providers was difficult. The material would show up the next day on a US website. You rely on kind of one brave complainant to file these complaints. It sucks up very scarce resources for human rights commissions, etc. It was still a tool in Canada's toolbox, other than the rarely used criminal code. So Section 13 was repealed in 2014. And in today's environment, I think resurrecting this section would certainly not be the answer to dealing with hate on the internet. There's so much to address. There's so many issues beyond human rights laws that it's certainly not a panacea. I'm just going to take one more minute. I know I'm running out of time. I just want to talk a little bit about what hate speech looks like for those who are worried that controversial and offensive views will be shut down. In Warman versus Cuba, the tribunal member, who's now Justice Karen Jensen, provided in her decision a concise summary of 11 hallmarks of hate, which is used to distinguish between hate speech and robust political discourse. The hallmarks are really descriptions of what hate speech looks like. And it's really based on the premise that you have a group of people that is innately inferior, subhuman, of no worth to society, innately evil, dangerous, and that we must protect the white race against these people. And so I'll just leave you with this. You know, some say that we should let it be so that we can see what's out there and then we can address it. Because clearly hate is a symptom and we have to get to the cause of it, whether it be misinformation, lies, etc. My question is, you know, does it exist outside of internet platforms? Does the anonymity and the connections the internet provides allow for a platform and an echo chamber which motivates those who are less rational to take action by confirming a very dangerous ideology that, to my mind, is very dangerous to our democracy and to a healthy and safe society. So I know that the other panel members have lots to share about what's going on now. So with that, I turn it over again to the panel.
Well, thank you, Annette. I mean, that is truly compelling about the urgency of actually addressing this challenge. And Owen, you have either the great luck or rather curse, but certainly challenge of designing regulation to address harmful content. So over to you. How do you see that probably being addressed?
Thanks, Chantal, and hi, folks. Luck or curse probably depends on where you sit. As Chantal said, my name is Owen Ripley. I am a public servant at the Department of Canadian Heritage, and I am responsible for overseeing the development of a legislative regulatory framework for online safety and supporting our minister in that respect. We agreed that, you know, my role in today's panel would be a little bit to set the scene here in the Canadian context. You know, and the image, I've shared this before in other settings, but the image that always comes to mind on the online safety file is, you know, if any of you have ever kind of done a design thinking course, they give you that really squiggly line that kind of, you know, talks about, you know, the process to looking at a problem. And I feel like that's kind of the squiggly line that we're currently in the middle of on online safety. So, you know, if we think about where we started from in the Canadian context, you know, the story goes back to just prior to the 2019 federal election here in Canada, where you saw, you know, the Liberal Party put out this commitment to put in place new regulations for social media, including, you know, a takedown of certain kinds of content within 24 hours. And after the Liberal Party was elected as government in 2019, this commitment made its way into the mandate letter of the Minister of Canadian Heritage, and he was tasked with moving that forward by the Prime Minister. I don't have any privileged insight into that election commitment, but what I can say, is if we go back to the lead up to 2019, the German Netz-DG model was certainly one of the prominent international examples of online harms legislation at the time. Since then, we've seen a lot of international developments, and I think Lorna is going to speak to this, but we've seen kind of the UK online safety bill be fully fleshed out. We've seen the Digital Services Act in the European Union, and we've seen the expansion of the e-safety framework in Australia. So this has been a very active space since 2019, and these international developments have certainly helped, I think, expand the thinking around online safety legislation, and we've seen a lot of evolution in that space. So in July 2021, for folks on the call who've been following the space, they know that the government published a detailed proposal of what a 24-hour takedown framework could look like in Canada. And I won't spend too much time on what that proposal is. Happy to kind of get into it a little bit more if there's questions, but the focus was on 5 categories of content grounded in concepts of criminal law. So we were talking about the incitement to violence content, terrorist propaganda, the non-consensual sharing of intimate images, child sexual abuse material, and hate speech. And that proposal set out essentially obligations on platforms to moderate those 5 categories of content. And then the proposal also, set out in some detail kind of the procedural avenues that were available to users and civil societies to challenge those moderation decisions. The framework was to be overseen by a new regulator, the Digital Safety Commissioner, and it was also to include a Digital Recourse Council. So the objective of going out with that detailed proposal was to provide an opportunity for Canadians to understand what was being contemplated prior to the tabling of a bill. And I think it's fair to say that what the government heard from Canadians was that there was significant concerns with the framework that was being contemplated. Among other things, we heard about concerns about freedom of expression. We'd heard about concerns about privacy. We heard about concerns about linkages with law enforcement and national security agencies that were being proposed. And we heard about the risk of undue impact on certain marginalized communities in Canada, including racialized Canadians. We had an election at that point, so we had an election in fall 2021, and when the current Minister of Canadian Heritage was sworn in, he was again tasked with moving forward as quickly as possible with a legislative regulatory framework for online safety. But the key was he was also tasked to kind of adapt that proposal, taking on board the feedback from those 2021 consultations. So when we picked up the file again in October 2021 after the election, and we had concluded our preliminary briefings with the current minister, it was clear that there needed to be a reset. And so the first step in that reset was to publish a detailed What We Heard report that set out the good, the bad, and the ugly of everything that we had heard in those summer consultations. The next step was to pull together an expert advisory group comprised of diverse experts from different backgrounds with a variety of different expertise. So folks with background in tech law, constitutional law, human rights law, folks from civil society, and I think I saw that Emily Laidlaw earlier today. So she was one of the co-chairs of that expert advisory group, and I trust that she will make sure that I don't mischaracterize anything in that respect. But the goal was really to get this group of experts together, which included folks who had been extremely critical of the government's 2021 proposal, and to get them to give the minister and the government advice on how to move the file forward. And so those experts met intensely over the spring. They didn't agree on everything, but I do think it's fair to say that there was broad consensus on what should essentially be the core thrust of a legislative regulatory framework in Canada. And that was to move away, from a takedown approach to what the experts called a duty to act responsibly. And that I see Lorna chuckling at that. So the concept of duty to act responsibly, my impression was in having observed some of the expert discussions and reading the reports is that it really emerged from a reflection on product safety law more broadly, and the fact that generally in society we expect that when product manufacturers are putting out a service or a product, that they are required to think about the harm that could be caused by that product and to take steps to mitigate that harm. And the example that's frequently used is you think about seatbelts and other safety measures in cars. And so the question really was, well, why aren't we thinking about online services through that same lens? So at its core, and again, I think you do see parallels with some of the other frameworks that are emerging internationally. This idea of a duty to act responsibly involves three things: so risk assessment, so what harms could be caused by the service offering; mitigation, so what steps can be taken to reduce those harms; and transparency. So reporting on the results of that risk assessment and the effectiveness of the mitigation measures. And the idea, as I have kind of synthesized it, is really to create a cycle of continual improvement where platforms are meaningful, leaning in to making the online environment a safer and more inclusive space for Canadians, and that civil society and the public more broadly have a clear line of sight into how that's playing out. So, since the expert advisory group concluded their work over the summer and the fall, the minister has been on the road, so to speak, testing out this idea of a duty to act responsibly with civil society, community organizations, and other interested parties through roundtable discussions. These roundtables have been an opportunity to hear directly from organizations about how to best mitigate some of those concerns that I mentioned earlier, that are real concerns about the government getting into this line of business. We've also used the roundtables as an opportunity to solicit feedback on more specific elements of the proposal, which the experts struggled with, and that I think there's still debate about. So questions around scope, what kind of platforms and what size of platforms should be subject to this duty to act responsibly. Questions around meaningful recourse, and in this space, particularly as it relates to child sexual abuse material and the non-consensual sharing of intimate images, where victims and victim advocacy groups have been very clear that one of the legal recourse that they are looking for is for that content to get off those services. Questions about appropriate linkages with law enforcement in relation to criminal activity, and how in the context of, if there are linkages, how you protect more vulnerable and marginalized communities from over-policing, from over-reporting, and those kind of things. So that's where we're at now. The final roundtables wrap up over the coming weeks. And then the job really is to work with the minister to finalize the proposed approach. And this was one of the 100-day commitments, so to speak, and so the goal does remain to table legislation as soon as feasible. There you go, Chantal. You're on mute there, Chantal.
The line of the year. So what I wanted to say, Owen, is that I see the intensity of the reaction to your first iteration of the bill as evidence of the complexity of the issue. And so I think it's very interesting right now that we're going to move to Professor Lorna Woods, who's sort of ahead of us because the UK has more of a defined path forward now. So turning over to you, Lorna, as to how the UK has addressed that challenge.
Thank you for the introduction and thank you for inviting me. I'd like to start with a question, and I think I'm picking up from some points Owen has just made. And that's about what is the best approach to regulation. So I'm making a distinction here between what I've termed systemic regulation and direct content regulation. And in a recent debate on the Online Safety Bill in the UK Parliament, the then Under Secretary of State for Digital Culture, Media and Sport, Damian Collins, said in response to the debate, "I take exception to the suggestion that this is a content moderation bill. It is not, it is a systems bill. The content that we use and often refer to is an exemplar of the problem. It is an exemplar of things going wrong." So what's he talking about in this distinction? Well, historically, and if we look at, say, broadcasting regulation, what we've done is identified types of content, and these are usually on an item by item basis, ex post response, and dealt with on the whole by the binary. Does it stay there? Is it allowed? Or does it come down? And in the context of social media, we've maybe backed that up in some instances with liability for third-party content for failure to act. Systems regulation does something different. We've got systems in the meaning, two meanings here. The first one is by systems we talk about the system itself, the software system, the business system, the product on which that content sits. The second meaning of systems regulation is the idea of having a process in place to deal with what we might call product safety. That is, look at what's happening, do a risk assessment, and try to mitigate. This approach is based in the recognition that social media platforms and search engines are not neutral as to content. They're designed to optimize user engagement, not user safety or informed discussion. And this seems to have led to the prioritization of emotive, extreme and divisive content, a communications environment where frictionless communication removes space for nuance and time for thought, and moreover incentivized the creation of clickbait through advertising revenue sharing. So other complex industries are expected to engage in safety protocols. Most products undergo safety testing. So the question that the systems approach asks is, why not these? In essence, we're looking at safety, risk assessment and safety mitigation, whether through safety by design or safety tech and user empowerment tools. And as the UN Special Rapporteur for Freedom of Expression, David Kay, said in relation to hate speech, this means interventions can be more nuanced and proportionate than regulatory interventions that focuses just on takedown. What you've got is a range of places in the information distribution chain where there can be interventions that affect information flow and information creation. So what about the Online Safety Bill? Well, there's a little bit of a glitch going on in the UK. It's been an interesting time politically, and that has meant that the Online Safety Bill has perhaps not gone through Parliament as fast as it could have done. So it's temporarily paused. We're expecting it back. But what I'm going to talk about is the version of the bill that was 2/3 of the way through the Commons before we went into the leadership election for the Tory party. Top line news on this is there are substantial systems elements in this bill, and I think that's good. But these exist under a heavy wrapper of content concerns, and I think that's much less good. The content concerns may be necessary or natural. Damian Collins suggested that it's through content that we understand the nature of the problem. But it has led to there being a very complex bill. So I hope you're all well buckled in, because I am now going to rattle through the structure of the bill. Happy to recap or answer questions when I get to the end of this with a deep breath. First off, services in scope. We've got user-to-user services. That's the term used for social media platforms. We've got search services and then some bolt-on provisions relating to what we might call professional porn services. I'm not going to talk much about that last group because it really is a bolt-on. Social media platforms are subject to more onerous obligations than search. And within each of those two service categories, some bigger, riskier platforms are subject to more onerous obligations than others. Duties comprise risk assessment duties and what are called safety duties. These are essentially duties to mitigate the risks. But the way the risks should be mitigated to some extent depends, first of all, on the classification of the service, and then the classification of content. There are three types of content which the bill distinguishes between: illegal content, that is content the possession, creation or dissemination of which would be a criminal offence, content harmful to children, and content harmful to adults. The obligations in relation to the criminal content are more stringent and tightly drawn than those in relation to children's content, content harmful to children's, and then the harmful to adults category is very lightly regulated. Within each of these categories, there is a subcategory. Are you getting the theme here? This is the subcategory of priority content, which in each instance is subject to more detailed rules on the face of the bill. Illegal content duties apply to all services. Children's duties to those services likely to be accessed by children. Duties in relation to content harmful to adults, however, are only applicable to the large and risky social media platforms. They're called Cat 1 services. All services have obligations to take freedom of expression and, to a lesser extent, privacy into account. Cat 1 services have extra duties in those regards, plus duties in relation to democratic content and journalistic content. And then there's some more bolt-on duties with regards to fraudulent ads. The risk assessment duties focus quite heavily on functionality, design, and operation of the services, as well as the user base and the type of content. The safety duties, with the exception of harmful to adults, are focused on outcomes and expect the design of systems. So that's what they're phrased as. Please design a system, please take steps to mitigate. The harmful to adult duties, however, are pretty much just transparency obligations backed up by user empowerment tools, but only in relation to priority content. And I'd like to make it clear that there is no obligation to censor or restrict harmful but legal content. We've got a regulator, Ofcom, as well as enforcing. It has got to produce guidance and some codes of conduct on how to comply with the rules. But these are going to take a time to be drafted, which I think will affect the entry into force of the obligations. The obligations only kick in once that information is out there in public. So, you know, we're talking what, 2024? That's my guess. I'd like to finish with some criticisms of the bill. The first one, and one I've made, is the bill is very complex, as you might have gathered from the way I rattle through that and all the subcategories and the different types of rule. This is probably because the government wanted to chart a path through competing interests, but it's actually left with an untidy stack of rules focusing on these types of content, begging questions about definition, and then compounded by a very circular approach to drafting, and then the subsequent add-on duties relating to fraudulent ads and pornography did not help. The extent of the powers the Secretary of State has a concern, and again, it's a concern I share. There are powers for the Secretary of State to designate through regulations, statutory instruments, the categories of priority harmful to children, priority harmful to adults, and add to the list of priority criminal offences. And so there is some, I think, legitimate concern about the level of oversight as that would go through Parliament. More technically, the Secretary of State has powers, I think, too much to interfere in Ofcom's code making and implementation of the regime. And I think there are concerns about Ofcom's independence, which actually is central to maintaining a pluralistic environment and maintaining freedom of expression. I'd like to conclude by talking about the category harmful to adults, which has got a lot of flack. And I think people are mistaken. Just in case there's any doubt, I don't have a problem with harmful to adults. And there are two aspects to this. One is the nature of the content in there, but also the nature of the obligations in the bill. So this content has been portrayed as regulating for hurt feelings, and I don't think that's the case. There's a triple threshold before content can be considered harmful. So the definition is content which firstly presents a material risk, of secondly, significant harm, and thirdly, to an appreciable number of adults in the United Kingdom. So that's quite a threshold to get over, and I wonder where it leaves minoritized groups. The distinction between harmful to adults and criminal content, I think, is an unhelpful binary. It implies that there are just two types of content, that contrary to the criminal law and that which is completely acceptable with regards to the law. And this completely ignores the fact that we've got regulation and civil law that are there to protect a range of other interests. And if we go back to the little saying, what is legal offline should be legal online, then I think if we regulate, for example, advertising or pornography offline, we should have regulation online. In any event, as I think Manette mentioned, content in this category can be very harmful indeed. It includes material that falls short of the criminal offences, sometimes just for technical reasons, or is just really, really nasty. We've got discussions at the moment about cyber flashing and what falls outside that for technical reasons, and extremism in the UK is not a criminal offence. Terrorism is. My final point is the nature of the obligations. As I've mentioned, what we're looking at is essentially information to be given to users as to how the platforms deal with certain types of harmful content, an obligation on the platforms to consistently enforce those terms of service, that is in relation to priority content only, not in relation to all harmful content, bizarrely enough, and also to provide user tools, again, only in relation to priority harms. So this is not a takedown regime. And I return to the point of the UN Special Rapporteur on freedom of expression, who suggested that other mechanisms beyond takedown, about tagging, about nudging people, may allow people to coexist more peacefully online than just saying, is it here or is it not? So happy to answer any questions, but I'll hand the mic back to Chantal.
Well, thank you very much. As I listened to you and to Owen, I find that there's a common thread there of the importance of having what I will call, if you allow me, a modulated approach, right? Nuance. I would like to turn to Errol now to bring this issue to another level of government, so to speak. Owen referred to the EU Digital Services Act. There's therefore like a broader context. Over to you, Errol, to place the subject in that context.
I will be focusing on the EU digital services, but I also want to have a larger framework, which you'll be pleased, Chantal, that I'm actually going to try and start with something which Chris Parsons said at the very beginning of the seminar, which I think we should keep in mind. Remember, he said he took us through this magical mystery tour from the start of the internet to where we may be now. And he emphasized the clash of ideas and the clash of ideology, starting with the libertarian approach, the free internet, etc. And then we went on to those who, as Monette has said, that there is a clash between freedom of expression and discrimination and targeting of minority groups. And one of the things which I have noticed, and I've been front and center in some of these areas as a human rights adjudicator under the Ontario Human Rights Code, and then later on under the Canadian Human Rights Tribunal, I saw front and center how those clashes were appearing not only between the people who were being accused of things, but also between those who were judging and those who were bringing the issues, including the commission and others. And one of the things that started occurring to me is that this is going to be resolved by government eventually saying, look, we cannot please everyone together. We may have to end up coming up with a system which will focus on process, something which Lorna has called systems. But I want to talk about it in the context of an even bigger form of a duty to show responsibility, not just a systems, but a duty to show responsibility. And ultimately, I think what the EU has set up is the mega contents and the mega systems approach. And if I can ask someone to put on the slide a brief description of what's on the Digital Services Act. Okay, so I'm going to go through this very quickly because I only have 10 minutes. So let's just start with who the Digital Services Act covers, and it's pretty much everyone. Anyone who's basically an online intermediary. It basically covers also, it harmonizes the illegal contents online. It also deals with some of the issues which was discussed in earlier panels on deceptive advertising, on actually the recommender system where where individuals are followed through in terms of what they look at. But I think the most important part of the in terms of the general framework. Okay, I'll just keep on talking as what you will see once they get the whole system up. So what the Digital Services Act has decided to do is we're going to have different obligations from the smallest online intermediaries to the slightly larger ones, which deal primarily with hosting, to the ones which deal with social media, and then ultimately the mega platforms, what they call the vaults, the very large platforms, and also the very large search operations. So that's the area where I'll focus most of my my comments, where essentially they've followed to some extent the same approach that the UK has, where they're focused on not on the content, but on a system which requires these platforms to first of all engage in very detailed risk management, which requires them to look at everything they have done to identify what are the potential risks, from the illegal to the harmful but lawful, to other areas, including the impact on children, etc. Once they've done that, they have to show it. So the next part of the focus becomes the focus on transparency. They have to show what they're doing in terms of their risk management. If they have in their reports that they do not have the ability to do proper mitigation measures, that will be required of them. So that's the next part of the approach which is required from that. So as you can see at the very bottom, the most significant thing of the whole process is a special due diligence obligations, which requires mandatory risk management, and then there is a requirement for them to subject them to independent audits. And the due diligence chapter of the Act specifically recognizes the systemic risks to the fundamental rights stemming from these platforms. And the effectiveness is really going to be measured by future delegated acts and guidelines, which have yet to be drafted by the Commission. Now, I just want to emphasize where this is at. So the whole Act was approved of by the Parliament. It is now in the form of a directive, which has to go through all the 27 legislatures to eventually become part of the legal system of each of the members. However, that being said, one of the issues which I would love to have a further discussion on with my colleagues on this panel, and indeed the audience, is if you look at all the different aspects of this process. If you just go up a little bit, if you look at the first part, okay. So in terms of the transparency approach, and what they call the algorithmic accountability, that's going to require looking into the black box. How effective is that going to be? And it very much depends on all the different types of the online intermediaries are willing to show what's in that black box. Also, in terms of the illegal content, a lot of it is going to be dependent on what's called the trusted flaggers, who will submit, and they're going to be authorized by a unit of each country to basically require platforms to look at what they consider illegal content, etc. There are huge scopes of controversy just on that point again. While we think of illegal content as fairly clear, no, it isn't. There's going to be many different aspects of what is going to be regarded as illegal in different countries. And then how do you respond to it? The next level down, the harmonization of response to illegal content, as you can see, requires that intermediary liability to act when they detect illegal context based on either individuals coming forward with what they consider illegal or these trusted flaggers. And how are they going to diligently respond to that is going to be very interesting to see how it works out. I'm not going to go into the other parts which actually dealt with some of the issues in previous panels dealt with, such as deceptive advertising and also the so-called recommender system. And so one of the issues, I think it's time for any country which is interested in dealing with this online harm is, what is at the root of this problem? And I would like to go back then to Chris Parsons' opening statement that essentially through his magical mystery tour from the start of the internet to where we are now, we have seen time and time again the clashes of not just interests, but ideologies and approach to how to deal with this. And so one of the things which I would love to have some discussion on is it at a certain point, is it time for governments to say, we hear that you all have your positions, your ideologies, but for the interest of society as a whole, we are going to start and take a risk, and what we're putting forward may work, it may not work, but we have to do something. And the way I like to analogize this is, and again, I'm going to use two forms of sports metaphor. The first one is American or Canadian football, where it's a whole Hail Mary pass. I think this whole area is a Hail Mary pass. Something has to be done. Now we have very, very detailed frameworks for it to be done. The US has one. Sorry, the UK has one. Now the EU has one. Canada is desperately trying to come up with something. We've abandoned what we started with, as Monette has said, because we repealed one of the critical laws in that area. So now we have these process and systems frameworks. But I really think that in the context, the metaphor of American football is a Hail Mary pass. I don't know whether people who don't understand American or Canadian football, it's when the quarterback just throws something as far as possible, hoping that someone's going to catch it in the end zone. In the soccer zone, the one I like to talk about is where a good player sees the goalie's out of the net and decides to lob it way over his head and into the goal, as the famous Pelé, one of the greatest soccer players, did. I think this is a form of Hail Mary pass, or the equivalent in soccer. And I think there's going to be a lot of problems with it, but I think it's a result of governments finally saying something has to be done. We can't just agree with one set of ideas or one set of ideologies. We have to do something for the benefit of society as a whole. And I think it's going to be very interesting. Keep in mind that the fact that the EU essentially has applied it to anyone who is established in the UK or is doing services in the UK, that has de facto an extraterritorial impact. So ultimately, whether or not the UK actually passes its own laws, or whether Canada does it, my prediction is this is going to be like the GDPR. Ultimately, I think the European Digital Services Act is going to profoundly affect what happens eventually in Canada, and indeed in the UK also. So I'll leave it at that.
Thank you so much, Errol. I cannot resist. I would love to hear, Owen, you have essentially sort of given a message to government that you hope government will take a firm stand and say, I'm not going to give in to ideology. I'm going to elevate this to the public interest. You also mentioned you think that the EU Digital Services Act will be a beacon, a model. Owen, can I ask you to react to these comments from Errol?
Sure. Maybe I'll actually try to kind of tie a number of threads together from everybody who's spoken on this panel. You know, going back to Monette, you know, a lot of the times, right, when we have these discussions about online safety, the conversations are dominated by, you know, questions around content moderation and systems. And I think, you know, one thing that we heard very clearly from the expert advisory group, and you know, I think Monette was getting it to it as well, is the importance of also anchoring these discussions in human rights law and human rights law concepts. And I think, you know, the starting point for us is a recognition that right now, you know, depending on who you are and the color of your skin and your religion and your gender and your sexual identity, you know, the internet is not an equal opportunity place. And so, you know, yes, freedom of expression is important, but I think, you know, the driver actually from where I sit, or one of the drivers from where I sit, is actually, you know, ensuring that, you know, more Canadians actually feel like they can freely express themselves online, because I think there's barriers there that you know, we're not actually meaningfully grappling with. And so I think part of it is that, and you know, I think the message we got from the expert advisory group is make sure there's a healthy tension between kind of making sure that platforms understand that they are accountable for upholding human rights, freedom of expression, privacy, you know, in terms of the systems and processes they put in place, and that needs to counterbalance, you know, any obligations they have to mitigate harm where, you know, some of those concerns about you know, undue impacts come up. And so if you get that balance right, and you kind of, you know, really make sure that platforms know that they're seized with that kind of a healthy balance there, it helps kind of ensure that we don't lose sight of what fundamentally we're trying to achieve. I really appreciated Lorna hearing, you know, about the UK experience from where you sit. Obviously, it's a big comparator for us as we've done our international comparisons, right? I think, you know, when I think about the reflections that are currently going on right now, you know, obviously there are kind of parallels between the duty to act responsibly and the duty of care type model that emerged in the UK. You know, I think the tension and that we're trying to kind of resolve and work through right now is, you know, one of the criticisms, and you'll know it, that's kind of come up in the UK context, is like, be wary about kind of too much of outsourcing to kind of self-regulatory approaches. And so, you know, that's again something I think that we're trying to sort through. And as you spoke about, Lorna, as well, I think that, you know, one of the criticisms that comes up in the UK is kind of this question around, you know, it's a duty of care approach, but there are still very specific obligations with respect to certain categories of content that are quite prescriptive. You know, what we've learned from the Australian model, which we haven't talked a lot about today, but I think, you know, it's interesting because it's a bit of a different model than either the DSA or the UK online safety approach, is that it's, you know, I kind of tend to characterize it as a complaints-based model. And again, I think, and I come back to the two categories of content that I mentioned in my remarks of child sexual abuse material and the sharing of intimate images without consent. Again, one of the key messages we keep hearing in that space is like, if I haven't been successful in getting a platform to take that kind of content down, I need someone to go to help me do that, right? And so, you know, the question has come up about, you know, an ombudsperson function who would really be someone that, you know, a Canadian could turn to, and that you know, that individual would have the ability to potentially assess the merits of that, and ultimately really seek to have that content removed in those two categories. So again, you know, those are the pieces that we're juggling. You know, we're fortunate in that, you know, we now have some international examples to draw from, and so that's certainly, you know, what we're doing right now.
Thank you. Can you also tell us what you think about this idea that, like the GDPR for legislative frameworks, the EU Digital Services Act will become a reference?
So it's obviously, I mean, it's, you know, it comes up a lot now, right? Like the EU is a 300 million person market. So when it chooses to move, you know, it's important. I think, you know, industry is certainly, you know, advocating that governments work to align their models as much as possible, because again, obviously, you know, if you're sitting in a platform shoe and you're running a global business model, you know, you're concerned about approaches that vary significantly, right? So for sure, like the DSA, I think is going to you know, be an important marker. But again, I think, you know, if listening to me and Lorna and Errol, like I would say, you know, I think for the countries and governments that are moving right now, you know, you heard the echoes of, you know, similarities in terms of duty to act responsibly, duty of care, systems-based approaches, right? So I think there is a recognition that when you're balancing the competing interests in this space, and the really important competing interests in this space, you know, that systems-based approach is a way to do that, as opposed to kind of a content moderation type approach.
Which really arcs back to Lorna's point. Unfortunately, we are out of time. Thank you so much, all of you, for at the very least putting forward the issue as at hand and the complexity of their interrelationship. On that, I'm going to ask my colleague Monica Song and the president of the International Commission of Jurists, Errol Mendes, to close this conference. Thank you so much.